Okay, good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. Again, Wednesday, March 19th, 2025 at 4:25 in the afternoon. Now we're switching our gears again and looking at 342. We have Chair House Judiciary with us who had possession of the bill and took some testimony on their parts of it. And then was gracious enough to send it over to us this afternoon during the House session. She's got possession of it now. We're looking at data broker pieces in there, but thought it was a good idea for the committee to understand what judiciary looked at and what if they have any recommendations for us.
Excellent.
Thank you for coming in.
Yeah, thank you. Are cookies for witnesses as well? And it's like, look at this and I didn't hear anything you said because I was just thinking cookie. So, well, depending on what I say, okay, all right. It's anyway, Martin Lalone, representative from South Burlington, chair of the House Judiciary Committee. And so we spent all afternoon yesterday taking testimony on H342. We really were focusing on the need. We talked to people who we talk to all the time as witnesses, judge, prosecutor, defense counsel, and just to understand the need for this. And is this something that they are seeing threats and that they support having a way that could minimize individuals being able to get addresses and other personal identifying information on the internet. And pretty much everybody, except for the Defender General, was ambivalent, but all the rest of the witnesses and law enforcement, we had both chief of police and two different individuals from state police, one from the association, the union, and then another person as well. And they all are in favor of anything that could be done to essentially create a barrier or a barricade from being able to get personal identifying information on the internet. We leave it to you to figure out if this is going to do that, because we're not the experts whatsoever on data brokers. But what I want to do though is, and the committee, not unanimously agreed with they agreed with this point, but I know that at least one individual and maybe second individual was concerned about that this is ripe for abuse by attorneys, that attorneys are just going to be bringing cases. And so that was a concern that was addressed. And another individual said the intent was okay, but again, also worried about the enforcement mechanism. But that was a minority opinion in our committee. We were otherwise fine with that. But I'm going to walk through and just point out where people had concerns, and most of these concerns are for you folks to decide if you think it's a concern. But since we did spend a lot of time on it, I figured we at least share what we had concerns on. So, and I'll go through the bill as introduced, and it's starting on page 4 and lines 10 and 11. The concern was with respect to the language include within a searchable list or database. And the concern was expressed that there are lots of companies, these companies probably also have internal databases that are never searchable by the public, and want to somehow tie this to that it's searchable by public. I think that makes sense as far as that concern. That it seemed a little broad, but again, leave that to you to try to figure out. The next is actually some suggested. I'm going to have one particular suggested language change. And then I'm going to also suggest, and I don't have language, I haven't talked to Rick about that, but would suggest some additional additions to the covered people, which I'll get to in a moment. But the language change was suggested from Judge Zone, and rather having him come in here and say that to you if you were not planning on having Judge Zone in, it's on page 4, line 20 and 21, and it would be striking of the on line 20 and inserting in a state court located in, that's what you would insert. So it'd be judge means any justice, judge, or magistrate in a state court located in Vermont. And then strike on line 21, Supreme Court, Superior Court, or Vermont Judicial Bureau. That was a suggestion from Ted. Don't need them passing on that we got. So here are the additions from our testimony as far as we would recommend as additional covered individuals. First is victim advocates. And there are victim advocates, and this is where your legislative council will probably need to work on the language, but there are victim advocates that are with the Department of Public Safety and the Vermont State Police. There are also victim advocates who are in the state's attorney's offices. And they face the same issue, if not more so, than others. For the state police, there's also mental health crisis workers are embedded, and the state police, in fact, testified that they more often are getting threats than the state police are. So, but they work with the state police, so I would suggest that as well. For the courts, court staff are public facing, and they also, because they're in the courts, they face this as well. But also the staff of the state's attorneys are frequently dealing with individuals who will reach out and threaten them. So I understand that you're already adding the Attorney General. I understand that they came directly to Monique. And also on line 12 of that page 5, where it says U.S. Attorney or an Assistant U.S. Attorney in the District of Vermont or the District of Vermont. I think you'd want to narrow that. One other, I received an email from Big Hartman. I think I have forgotten the last name, from the Human Rights Commission, and they deal again with lots of situations where they're getting the same kind of threats and would also like to be included as a covered person. And we supported all those additions. We thought all those made sense from what we were hearing. One concern that came up, and I understand that this is on line 16 on page 5, the home telephone number. I understand there's a definition of home telephone number, but kind of jumped out at folks that people don't have home telephone numbers. They have personal telephone numbers. Just want to flag that whenever you're going to do that. I'm just passing on. I'm mostly a messenger from the rest of my committee. On page 6, the issue is where it's talking about disclosure, the prohibiting disclosing of this information. A member also said, well, is that going far enough? Should it be deletion that information should be deleted? Passing that on to you, that's completely your decision, of course. And then I think I understand that you probably already know that the 10 business days was probably one of the biggest issues that people were concerned about, that it was, is that too short? Should it be a reasonable time? Should it be 10 days per individual that they're seeking to purge or not purge, but not disclose? There's lots of ideas. I explained that relates to the functioning of data brokers, and you have all sorts of people who are going to hear about that. But I just want to flag that as that was kind of like a top concern. That was not within our jurisdiction. So the other concern that is in our jurisdiction, and I don't have any suggestion on this, this is the remedies. The remedies section really is within what we deal with. And that's on page 7, and it's lines 10 through 18. And that is, we were fine with punitive damages. Courts can do that anyway. You don't really actually have to have that there, but it's fine that it's there. Reasonable attorney's fees in this kind of litigation. Most of the time we don't have reasonable attorney's fees, but consumer fraud and those kind of cases, there's a good reason to have that. Otherwise cases won't be brought. Preliminary and equitable relief, fine as well. There was concern about the $1,000 for each violation, and it's more of a concern as far as what it constitutes a violation. And this, once again, is probably how do data brokers work for you? But the concern was, all right, if somebody, say the state police, they gather everybody together and they have several hundred, or it's not that big, a couple hundred state police that collectively go to the data brokers. And the issue is that is it every time they disclose? And presumably the way I read it is it's like if they keep disclosing that information, it's every time there's a disclosure of the person's information. It was raised as a concern. Does that make this, does this attract too many attorneys who want to bring these cases? That kind of concern that I mentioned first. I just want to flag that you made that you all understand that was an issue that was raised. Two final things, I think. I'll just check on a couple other things. So on page 7 as well, line 20 and 21, fine with the negligence. We talked about the negligence standard. That makes sense, making it clear that it's not strict liability. But the next provision, as far as it shall not be a defense to liability in a judicial proceeding that the covered person's protected information not available elsewhere. We looked at it and it's like, well, that didn't make a lot of sense to us, but there may be reasons that we don't know about that does make sense in the world of working with data brokers. It seemed like that should be a defense. If the information is out there anyway, why shouldn't that be a defense? Again, we didn't have come out and say you should do something about that, or flagging that. Let's see. Let me make sure I got everything. The final thing is that we recommended, and I did talk to Monique about this, that there be some sort of criteria or something put into place to be able to down the road do oversight to see if this is working. And how you do that, again, we leave that to you, but we think that that's pretty important. And actually, we've been trying to do that with most of our bills is if there isn't a clear way to monitor whether something's working, we're mandating that whoever is doing something, that they come back to us with a way that we can monitor. So I think that is it. Now, I'm happy to answer questions, but if there's anything specific regarding what is within our jurisdiction.
I just have a super quick one. About so the parole board also reached out asking. I don't know. I don't even know.
That's in here.
Oh, okay.
I mean, I did see that, but I saw covered persons, parole and probation officers. Well, all right.
Okay.
Well, we didn't hear from them. If it's a pro board, if there's somebody different, that would apply. Yeah, I had mixed that up. Oh, there was one other thing I did want to mention, that this is civil. I know that there was talk in our committee by a witness that the New Jersey law has a criminal component to it. This doesn't have a criminal component to it. If you are interested in adding a criminal component, that really is within our jurisdiction. We'd have to take a look at that again. So just wanted to flag that as well.
I love the idea, like you said, of tracking how that goes on. Do we have any mechanisms or systems in place right now for some of these? Is there a reporting system or something where if they receive a threatening phone call or a threatening email, can they report that anywhere?
This would be other witnesses besides me. I don't know.
Okay.
I heard of Building and Grounds that somehow keeps track of some threats, but we did not follow up on that. But yeah, you probably want to ask other witnesses.
I know Rep will have a meeting that he's already late to, and we have.
I was trying my best to have as long of testimony as I've already really. So you can't keep me longer? No, I love the chairs meeting. I love the chair.
It's just down the hall, so we can pull him back in, I think.
Yeah, yes. Yeah, absolutely. Absolutely. It's a good bill, and the folks we heard from definitely hope it keeps on moving. So thank you very much.
Thank you. Someone would send those cookies down.
You gotta gas up for my testimony.
been a long day. Good cooking too. It's virtual.
Thanks, everyone. Representative Monique Priestley. Well, so, we stand at a precipice. Recent events, both nationally and with our own states, have laid bare the stark reality. The unfettered availability of sensitive personal data online has transformed from a matter of inconvenience to a clear and present danger, threatening not only individual privacy, but also the very foundations of the rule of law and our democratic institutions. We are not just facing a storm, we are in the midst of a crisis of personal security and public trust. Last year, this committee engaged in critical discussions about online privacy and surveillance. Since then, the threat landscape has only intensified. We witnessed a cascade of alarming incidents, including the United Health breach and executive targeting, the cyber attack on United Health, followed by subsequent removal of personal information of corporate leadership from public view, underscores the vulnerability of even the most powerful institutions to data breaches and the chilling effect that it has on personal safety. Escalating threats to the judiciary as another example, as reported by Reuters, federal judges are expressing grave concerns for their safety. The U.S. Marshals Service has briefed judges on these mounting threats. We've seen reports of judges receiving unwanted deliveries. Pizza last week, I don't know if people saw that article, is one in order to intimidate. A tactic law enforcement interprets as a form of intimidation designed to demonstrate the ease with which our homes can be located. This has led to judges needing additional security. These are not isolated incidents, they're symptoms of a systemic problem. Daniel's Law and its implications is another example. Crucially, the legal precedent is on our side. The successful defense in federal and state courts of New Jersey's Daniel's Law, enacted in response to a horrific tragedy, which you'll hear a bit more about, demonstrates that protecting the personal information of public servants is not only necessary, but constitutionally permissible. The federal court's upholding of Daniel's Law provides a strong legal foundation for the bill I'm introducing today. The challenge faced by Daniel's Law is key to consider, as its failure would have undermined the standing of every privacy law in the country, which is one of the reasons it came on my radar and I was tracking it. These events are not disconnected. They are interconnected manifestations of a single pervasive threat, the weaponization of readily available personal data. This data, often obtained legally through data brokers or scraped from public websites, is being used to harass, intimidate, threaten, and even physically harm individuals, particularly those in positions of public service. The bill before you today, H342, directly addresses this crisis. It is narrowly tailored to protect the online privacy of those who serve our communities, judges, law enforcement officers, prosecutors, municipal employees, and other designated public servants, individuals whose work is essential to the functioning of our government and to the maintenance of our democratic values. These public officials are the keystone of our democracy. This bill is not about stifling free speech. It is about protecting the safety and security of those who dedicate their lives to public service, and by extension, safeguarding the integrity of our democratic institutions. It is about recognizing that the unfettered availability of personal data, particularly in the digital age, poses a unique and escalating threat that demands a targeted and effective response. It's about acknowledging that the rights to privacy, particularly for those who uphold our laws and serve our communities, is not a luxury, but a fundamental necessity. As a Vermont judge providing witness testimony on the bill to House Judiciary said yesterday, tragedy hasn't struck Vermont, not yet. I urge this committee to give this bill its full, careful consideration. The time for action is now. The safety of our public servants and the stability of our democracy depends on it. Thank you.
Thank you. So as one of the sponsors of the bill, anybody have any questions for Rep. Priestley?
You'll have to get a walkthrough. So, yeah.
So you heard a lot of the testimony, I think.
I listened as much as I could. There was multiple hearings on multiple bills, so I was juggling back and forth all day.
Came in with,
Yeah,
not necessarily suggestions for amendment, but suggestions to take a look at, I guess.
totally. Yeah.
And I'm curious, how you felt about the things he mentioned.
No, I mean, generally, like, went through all those things with him after yesterday. And then also there's like a few additional ones we've been hearing from representatives of different companies. So there's lots, so as far as all the things he said, there was a few things that we need to clarify, but in general, like they made sense. And then there's additional things like we've also heard the day extension from other representatives. So like that makes sense to look into. What else was there? Trying to, yeah, go ahead.
The day extension is.
So it's 10 days. Yeah, exactly.
They have to, she's disclosing, is that it?
Yes, Rick, help me.
Rick Sagel, Office of Legislative.
There we go.
So, right, they have from notice, they get notice from either the person or a assignee agent of the person, a company, the attorney. Once they receive that notice, they would have 10 business days to cease disclosing that information.
Cool. And then, so there's been a request to change that to 30 for multiple people.
Oh, I see.
Yeah.
Put it up.
Give them more time.
And what was,
Uh,
what you thinking about that proposal?
I mean, I think that's definitely something to entertain. Like it generally that seems to make sense as a thing we could do. Yeah.
Okay.
But it's up for the whole committee to decide, obviously.
It's the policy that we have to figure out.
Yeah.
Okay.
So this pertains to individuals. They're protected while they're in this employment
And after, yeah,
and
it
after-
follows them. Yeah. And their families.
and their families. And so if someone gets divorced, is the former spouse, I mean, are those things?
We'll have to like dig into that with Rick.
It's something to think
That, I mean,
through.
that is a good question. I'm
Alright.
not sure about divorce and how that works in Vermont law and all
But
that.
but that it covers the individual and their family, which does that mean your parents if you're covered? Does it mean your kids? Like, do we have
Policy question that we'll dive into.
so what's the point of, what are we doing now?
It's just like a
This is an
framing.
Introduction to frame the
Yeah.
bill. We're gonna have Rick.
Rick will do a whole walkthrough of everything.
And then we're gonna hear a bunch of testimony on the bill. We have a lot of people lined up who want to talk about it, and we can push on these issues, these questions with those folks
I didn't
to
understand.
understand better where we want to end up with our policy.
Didn't realize how fast we were.
That's all good.
Well, no, we won't do all of it today, but we are gonna do all of it this week.
There we go.
So we have
Alrighty
today,
then.
tomorrow,
Plenty of time.
Yeah.
plenty of time.
Good.
I think so, yes.
Okay.
Okay, would you take us through?
Yeah, thank you. Vice Chair Grant.
Right. Rick Sagel, Office of Legislative Counsel. This is, I believe, the first data bill this committee's had so far. So congratulations. I'm also the data guy in addition to the business commerce IT, which is part of data here. So I think Brett Priestley really kind of covered section 1, which is the findings and purpose. You'll have other witnesses that testify to that as ledge counsel. Not really my purview for the findings and purpose. I'm going to skip to section 2, which is really the crux of the bill. So we are in the data brokers part of our code book, and Vermont, I think it was 2019, was one of the first states to not regulate. I think even David Hall spoke about this earlier. When it comes to data brokers, we require them to file a notice that they are acting in Vermont. That's almost the extent of how Vermont, quote unquote, regulates data brokers. So this would be kind of new requirements of these data brokers. So I'm going to kind of go in order, but I am going to focus on a couple definitions more than others that I think are important for you all to keep in mind. I think an assignee is pretty obvious. It's someone that a covered person, which we'll get to in a second, assigns their right to in this bill. Authorized agent is similar. It is a list of people that a covered person has authorized to act on their behalf. Could be a trustee or other agent pursuant to a written power of attorney or other legal instrument of any covered person who is physically or mentally incapacitated. It could be B, a parent or legal guardian on behalf of any child who's a minor and who is otherwise entitled to address redaction or non-disclosure. And most importantly, C, a person or entity who has been appointed pursuant to a notarized document by a covered person to act for the covered person for the submission or revocation of requests for redaction or non-disclosure of protected information. So this allows a covered person to, if they don't want to deal with the paperwork or whatever else of having their information removed, they could hire a person or a company to do that for them. Okay. Covered person, this one's important. So it covers, get out my notes too, because I was taking what Rep. Lalonde was talking about. It includes active or former judges, law enforcement officers, prosecutors, public defenders, parole and probation officers. By the way, most of these are also defined later in the bill. Municipal employees and employees of the Family Services Division of DCF. And importantly, the immediate family of these individuals. And Rep. Cooper asked about what does this include? So we have a definition of immediate family coming in a second, and I'll show you that reference. Questions about what a covered person is? Okay, a data broker is defined. I'm going to pull up the statute here. So we are in Title IX, and I want to show you all this because this is who will have to abide by the law. You have to be a data broker. And I think what's maybe important about this definition is what is not a data broker. Most data brokers you've probably never heard of. There are some that are name brands. Zillow could be a data broker, but most of them you've never heard of. They're companies you don't deal with. They're companies, third-party companies that deal in personal information, selling it, buying it, that kind of stuff. So it's a business or units of a business that knowingly collect and sell licenses to third parties, the brokered personal information of the consumer with whom the business does not have a direct relationship. And subdivision B here gives you examples of what a direct relationship is. It could be the consumer is a past or present customer, client, subscriber, user, or registered user of the business's goods or services, employee, contractor, or agent of the business, investor in the business, or a donor to the business. So right there, if a relationship like that exists with a business, that is not a data broker. They're not included in this bill or as a data broker. Subdivision C, the following activities conducted by a business and the collection and sale or licensing of brokered personal information do not qualify the business as a data broker. Developing or maintaining third-party e-commerce or application platforms, 411 directory assistance, providing publicly available information related to a consumer's business or profession, or providing publicly available information via real-time or near real-time alert services for health or safety purposes. And finally, the phrase seller licenses does not include a one-time or occasional sale of assets of the business as part of a transfer or control of those assets that is not part of the ordinary conduct of the business, or a sale or license of data that's merely incidental. So again, I think I didn't do this definition, this is before my time, but I think the intent here was to not include businesses that consumers deal with on a daily basis, that you buy things for, that you deal with. These are meant to be businesses that pretty much just buy and sell brokered information without dealing with consumers directly, for the most part. Questions about the data broker definition? Okay, so that's critical because that's what this bill applies to. So disclosure, disclosing, I'll let you read that. It includes every probably adjective of what that means. Sell, lend, trade, it goes on. Disclose can be a lot of things. So a data broker must cease disclosing would mean yes.
Can I go back to data broker?
Yep.
Is there a requirement of compensation or not? In other words, does a data broker have to be in the business, I guess, of doing data broker things or that's your own?
Well, they just have to knowingly collect and sell the third party's brokered personal information of a consumer. So do they have to make money? No, but wouldn't be much of a business
He talks about what cells. is. What it is.
Okay, I got it. No, that was helpful.
Sure.
Do you know how many there are in the state?
I don't. But the Secretary of State's office could provide that data since you have to
Over
register.
200. I think it's over 200. Yeah. We can get that one.
Yeah, that's an easy, that's public information. Yep.
Yeah.
Yep. Okay, and by the way, this would include data brokers outside the state of Vermont.
I guess that's.
Yeah, yeah. It's about Vermont protected people, covered persons, but the data brokers could be out of state data brokers. Okay, disclosing, I'll let you all read those fine words. Home address means your partial or complete street address or other information that reveals your location, home's location. It includes your tax parcel ID, legal property description, or geographic coordinates. One thing I forgot to make clear is that government agencies are not included in this definition data broker. It's also not included in our own definition data broker, but this bill makes it extra clear that governments are not subject to this bill. Yeah, right. That's what made me think of it. Home telephone number means, and this is Rep. Lalonde talked about this, that it does include cellular numbers. It's just a number primarily used for personal communications. So there are some people with home landline phones in Vermont, right? Especially, yeah. I've learned that so far. It's good to have a home landline phone. But of course, most people have cellular phones, so that both are included. We're really, if there's some other form of phone, satellite phone, if that's your personal communication, then that would be included too. Okay, immediate family, there's a cross-reference, and whenever it's not really clear what this cross-reference is, I pull it up just so you all can see it. So this definition is in 3 VSA 1201, which this is 12 VSA 301. Okay. So immediate family means an individual spouse, which means current spouse, right? Domestic partner or civil union partner, child or foster child, sibling, parent, or such relations by marriage or by civil union or domestic partnership, or an individual claimed as a dependent for federal income tax purposes. So to answer your question, a formerly divorced couple would no longer be the immediate family of the spouse.
Your brother-in-law, a sibling by marriage.
Current, yes, if you're currently married, correct.
But the divorce would sever.
Right, if they're divorced, it would no longer be in law, right? I would need to research that actually. Does this definition include in-laws as far as brother-in-law? I don't know if it would.
Well, it says such relations by marriage. I mean, when my son marries his wife, she becomes my daughter.
Right. But I that's my assumption, but I don't like assuming things. So anyway, if that's a concern, I can double check that for you. Sure. That's immediate family. Okay, judge, and I think this is where Rep. Lalonde had his first recommended changes. So the current bill says it's any justice, judge, or magistrate of the Vermont Supreme Court, Superior Court, or Vermont Judicial Bureau, and any judge or magistrate of a federal court in Vermont, or any person who serves as a judge, justice, or magistrate in another state who maintains a home address in Vermont. And the recommendation was to put in a state court located in, so right. Yeah, right here. So any justice, judge, or magistrate in a state court located in Vermont. So both these words would be removed. And then you'd remove this line. But I believe you would keep and any judge or magistrate of a federal court. Do you want to have a discussion about that, Rep. Granning, or just continue?
This is specific to judges, so people who work this.
Well, so this is a
Definition. And
Just
it's
definition. We haven't talked about who's covered yet. This is a definition of what that word means when we get to it later in the bill.
maybe my thought was, my thought there was, did anyone else law enforcement officers, municipal employees who maintain.
Different definition.
That's what I guess my question was, did that come up in talking about the definitions?
And for-
We will get to that one. So it is, I will say it is
It's the
important.
next item. I mean,
Yeah.
like, really, like, let's
Yeah,
take it.
Okay, so we'll talk about that. I've noted that, and maybe at the end we can discuss the proposed changes from House Judiciary. So the next is law enforcement officer, and I have that pulled up as well, 20 VSA 2351A. It is. Oh, don't close it. All right, so it's a big definition, and I'm not going to read it to you, but it's something you can look up, and if you're satisfied that covers every law enforcement officer you think should be covered by this bill, then it's pretty thorough. I'll just say that it's pretty thorough. So again, the statute's there, you can look at it, and, you know, obviously ask me questions if you don't think it covers something enough. Municipal employee,
We're on law enforcement officer.
Law enforcement.
I've gone to staff investigators. How do they fit in?
so this is like court staff, and that is something House Judiciary recommended that you all consider adding as a specific group that's covered.
And would investigators of
Some of
defenders?
some of them are included as
Okay.
law enforcement officers, so that's why these definitions are really important.
Okay, I'll look up.
So
Yeah, it's pretty thorough, but yeah, I would again, review it. And if you think, and you may hear from other witnesses who think that they're not being protected when they should be.
The law enforcement officer include federal law enforcement officers, or does that then make it a federal crime?
It would not make it a federal crime. And I'm looking quickly at this definition. I don't see federal, are you talking about like FBI or
Yeah,
ICE?
or, you know, even we in the Forest Service have law enforcement officers, so.
Right. Yeah, I don't think it does. I'm reading this as quick as I can, but I don't think it's just gonna be Vermont Police.
that's worth flagging as we look at the definition.
Moving on to the parole and probation officer, means a corrections services specialist employed by DOC or a parole and probation officer employed by Vermont County or municipality. And I think Rep. Ron talked about there's, or maybe Rep. Priestley, was there a request, Rep. Priestley? to add
Yeah, to add parole board, but it's just on the list of stuff.
parole board? Let me add that to my list, parole board. Okay, prosecutor means a Vermont state's attorney or deputy state's attorney or a US attorney or an assistant US attorney. So a couple things here. There has been a request to add the attorney general, which I think was a oversight on my part to not add them in to the introduced version of the bill. And secondly, this last part here is not specific to Vermont. So this would also inadvertently, I think, protect like a Hawaii US attorney. So if you want to limit it to Vermont, you know, that are in Vermont,
Residing in Vermont.
yeah, or that, you know, work in a Vermont state or federal court. Protected information means a covered person's home address, including your primary and any secondary address residences, your home phone number, which, you know, includes landline and cell phone, your personal email address, your social security number or driver's license number, and your license plate number or other unique identifiers of a vehicle owned, leased, or regularly used by a covered person. Okay. Last definition, public defender means the defender general, deputy defender general, public defenders, or really any other public defenders that are covered in 13 VSA 163, which I don't have that pulled up, but it is just the chapter dedicated to what public defenders do, who they help. But I heard no testimony saying that this needs to be adjusted. Subsection B, non-disclosure.
Yeah, sorry to be pedantic about that. I went out to the law enforcement and then I'm looking at the public defenders and I don't see their investigators. I suspect that was inadvertent.
So, well, no, because there was not this, the court staff thing was brought up after the bill was introduced. So this would be included in that, not just the court staff of the prosecutor's office, but also the defender, you
Oh,
know.
okay.
So we have court.
We haven't seen that.
Yeah.
Yeah.
Right. There's not court staff anywhere in this bill. Yeah. But there is a request to add that. Yep. Okay, subsection B, non-disclosure. Subdivision 1 just says that a covered person or an authorized agent of the covered person has the right to send notice to a data broker requesting that the data broker cease disclosure or redisclosure of the covered person's protected information. 2 is probably the most important subdivision. Upon a data broker receiving physical or electronic notice from a covered person or an authorized agent of the covered person requesting that the data broker cease disclosing or redisclosing protected information of the covered person, the data broker shall cease disclosing the protected information not later than 10 days after receipt of the notice and shall not disclose or redisclose the protected information after that time. Rep. LeBlanc talked about the deletion instead of disclosing. That's an option, but I do think that could create some issues with, I don't know if there's other laws we would want to think about as far as they have to keep data for certain other federal laws may come into play there about keeping data for a certain number of years or. So 3, the notice set forth in 2 shall be in a form provided by the Secretary of State, meaning that they would produce this notice that a consumer, covered person, could fill out and send to a data broker. They shall publish the form of notice not later than 90 days after July 1st, 2025. However, that until such form is published, covered persons and their agents may use their own form of written notice that references section, identifies the sender as a covered person or an authorized agent acting on behalf of the covered person, and request that the data broker cease disclosure of the covered person's protected information. Subdivision 4. Madam Vice Chair, I believe you have a couple of.
Go ahead, sorry.
No, sorry, and I apologize, I think I was out of the room when you did covered person. This is dealing with actual individuals and corporate individuals.
Covered persons?
Yes.
Well, ideally, they're, you know, we have this list of covered people, which is judges, law enforcement. But I can't say 100% yes, because what if they have 2 jobs? Is that?
Oh, I guess I was asking about corporate personhood.
Oh, right. No, just
and
individuals.
Organizational personhood.
Human beings with a heartbeat.
Okay.
Yes.
Okay, well, because I was like, well, also like the court being
Right.
the largest and a large entity, multiple people. I just want to make sure.
Right. Yes, the covered persons are individuals. Yep.
It's a valid question.
Sure.
Question about, I'm having trouble understanding, except that no prior verification of a covered person's or authorized agent's status shall be required for the notice. Does that mean there no vetting of whether they're a covered person or not, or nobody has to, what's not being verified or what's not required?
So you are, remind me where you are?
I am on 3, line 16 on page 6.
16. Okay, yes. So the except that no prior verification. So it's a really important line because the covered person or their agent, if you didn't have that there, then the data broker may say, we don't know this is you or not, like prove that this is you.
Okay.
And so if you didn't have that, you would need to probably have some kind of regulation as to how we handle that situation. And this is one end, right, where there's no verification. The other end is you let the data broker decide how they verify this is a real request from a real person.
All right, so the status that doesn't be verified is whether you're a covered person or authorized agent. That's the status that doesn't have to be verified.
Right.
Okay.
That's how I read it. If you read it differently, let me know because,
No.
okay,
Yeah, it sounded like it was,
Yeah.
you assert it and it's not something that can be
Right.
rebutted by the data.
if I submitted a notice, I would not be protected. If I submitted a notice on behalf of a prosecutor that I knew to try to help him or her out, then, and I didn't tell my prosecutor friend that I was doing this, they would have to accept, right,
I see.
that I am who I say I am, even though I'm lying. Does that
Oh,
make sense?
oh, well, that does make, yeah. I mean, I see what you mean.
Yeah.
Okay.
All right.
Okay.
Okay, let me continue on. So four, a data broker that receives a notice from a covered person or their agent that discloses or rediscloses the covered person's protected information more than 10 business days after receiving the notice is in violation of the section and shall be subject to the following penalties in civil action, either brought by the covered person or their assignee. So one thing that I noticed that I didn't catch when I drafted the bill is this calls for 10 business days. And the previous subdivision 2 just calls for 10 days. So I think we need to be consistent, either, and it may not be 10, maybe it's 30, maybe it's whatever, but that to me could be confusing for a data broker. You want them to comply, and we're giving them conflicting information, so it's mostly my fault that I didn't catch the business in between the days. Okay, so here are the, and Repilon talked about, this is not super common where we list out exactly the what the court can do, but doesn't hurt to give the court some guidance. You're allowed to do that as a legislature. So damages, which is either the liquidated damages, which means kind of like default, you do this, it's $1,000 for each violation, you deem it to be that important that it's worth $1,000. Or if it's greater than that, it's greater the actual amount of damages you've suffered. What would the actual damages be of your information being out there? It's maybe tough to assume, but could it be more than 1,000? Yes, it could be more than 1,000. But I can't say if it more often than not would be less or more than that. B, punitive damages, which is like a punishment. And it's only upon willful or reckless disregard of the law. Courts will rarely do that, but on occasion they do. If something's so bad, it was so egregious that it deemed you need to be punished for this. In addition to your actual damages, you have done something really, really bad. That's a punitive damage. Which, as Rep. Lalonde said, not commonly put in statute, but you can. A court can do it without you telling it can do it. C, reasonable attorney's fees and other costs reasonably incurred. Pretty typical for consumer protection, which this is. And D, any other preliminary and equitable relief as the court determines to be appropriate. That could be requiring the data broker remove the information immediately. That could be a court order. That would be a version of equitable relief. Questions about the remedies?
It's not really our area.
No. Okay. Subdivision 5. In any proceeding, pursuant to 4, the standard should be ordinary negligence. Rep. Lalonde talked about that. It shall not be defense to liability in a judicial proceeding. The covered person's protected information is or was available to the public from other sources on the internet or otherwise, or available by inspection in public records. Again, I think that committee heard testimony about that being potentially an issue with this public information. 6, a covered person or an authorized agent accessing a data broker's website or other public application for the purpose of determining whether the covered person's protected information is being disclosed shall not, as a result of such access, be deemed to have agreed on behalf of the covered person to any terms and conditions with respect to their rights. So this would prevent like a little checkbox on the website where you inadvertently waive your right to recovery. 7, a disclosure.
Can I go back to 5 just for a quick second? Just my reading of 5 is that if a data broker gives you the information, they can't say, but it was available somewhere else, so it's okay. But so the data broker is the one that has to have supplied that information. Is that an accurate reading of that?
I don't think so. I think what it means is that if this law enforcement officer's home address is available on a non-data broker website. Let's say it's available on, yeah, some other website.com, right? The data broker would still be liable for not removing it.
Because they didn't delete it, or they provided it, or.
There's no,
Because they didn't delete.
because they didn't delete it. There's nothing about who they provided to.
Because they, okay.
But the House Judiciary made an interesting comment that if you remove this,
Mhm.
this kind of loophole, closing the loophole, the data broker could just publish it, send it out to a publicly available website, and then they wouldn't have to cease disclosing, right? Maybe there's another way around that. I haven't thought about it, but that's
Seems to eliminate the whole purpose of the law.
right.
Thank you, sorry.
No, that's
Oh, Vice Chair,
Yeah.
you said delete, is that, well,
No, we're not talking about.
okay. All right.
cease disclosing.
Cease disclosing,
Yep.
okay.
Yep. Okay.
Under my breath that we're not really talking about delete, but I said it very, very quiet.
And then subdivision 7, a disclosure of protected information shall not constitute violation of the section if the disclosure A is made with the express authorization of the covered person, provided that it's after a non-disclosure request. So in other words, you change your mind. You ask for it to be deleted, then you say, no, publish it again. I don't know when that would happen, but it's there. Or B is for the sole purpose of facilitating a transaction initiated by the covered person. I might want to hear testimony on what that refers to. I'm not quite sure. We don't have transaction defined. So that could be a little bit broader than you want it to be. So
Any more questions for Rick? Thank you. I'm sure we will be talking to you a lot more about this. Our next person for testifying, I believe it's Justin Sherman, is on Zoom.
Can you hear me?
Now we can hear you. Yes, we can't see you, but we can hear you.
Well, let me fix
Stating-
that second part here. Just give me 1 second.
And then just remember to state your name for the record.
Yes.
Just for the committee, I do have a meeting too, so I'll be out. Kirk will be in charge, Mike will come back. We're shooting done by 6 tonight, and we'll pick up more tomorrow before lunch.
All right, there we go.
Great, good to see you.
Okay, and apologies for the glare. We're hitting late in the day as we all are. So, all right, I can go ahead and get started if you can hear me clearly.
Yes, please.
Okay, great. My name is Justin Sherman. Thank you to the chair and the vice chair and the ranking member and the distinguished members of the committee for the opportunity to testify today about H342, the data broker industry, and the importance of protecting those working in government and serving their communities from invasive and harmful privacy practices. As I said, my name is Justin Sherman. I'm a privacy and technology policy and national security scholar and consultant based here in Washington, D.C. I've spent years now studying the data brokerage industry. I founded and ran a research program at Duke University on the topic, have worked on countless efforts at the federal level, as well as in some states, to protect everyone from stalking victims to military personnel from data sales, and have repeatedly testified and provided nonpartisan advice to both Democrats and Republicans about how to understand, approach, and effectively regulate this industry. So I wear many different hats, but we'll be speaking today in my personal capacity. So I'm going to give an overview of two things here. First, the data brokerage industry as a whole, the assortment of harms and the reasons why all citizens of Vermont and the United States writ large, including government workers and public officials, deserve more control over the collection and sale of their data by data brokers. Second, I will talk about the arguments that data brokers often make to dismiss harm and distract from the underlying practices, and why these claims are an attempt to move focus away from provisions like in H342 that provide people with much needed protections for their privacy, the personal safety and security of them and their families, and another step towards more meaningful privacy in the 21st century. So first, the data brokerage industry itself. Data broker industry is a multi-billion-dollar industry in the United States alone, comprised of thousands of companies involved in collecting and selling people's data. While data brokers may be thought of in some narrow legal definitions as only third-party companies with which consumers don't directly interact, the practice of buying and selling data across the United States includes actually both first parties and third parties. That is, both companies and organizations selling data on their own customers and their own users, as well as third-party companies with which consumers never directly interact, who sell those people's data nonetheless. Data brokers get their data from all kinds of sources. They collect directly via trackers on websites or through companies, and indirectly, such as by paying mobile apps, retailers, and car manufacturers to sell their customers' data, and by scraping public records, and through inference, or prediction based on data already collected. I published a number of studies and worked on many investigations into the kinds of data sold by various brokers in the industry. Plenty of data brokers sell different kinds of data from one another and in different formats, and sometimes to different buyers too. Buyers can pick and choose across different data brokers that collect and sell people's demographic data, such as race, religion, gender, sexual orientation, marital status, and number of financial data, such as debts, mortgages, gambling habits, online purchases, and propensity to spend money on alcohol, cigarettes, condoms, and over-the-counter painkillers. Health data, including health data about specific procedures and operations, as well as data on mental health prescriptions, strokes, cancer diagnoses, people with children with special needs, and more. Political data, such as campaigns and candidates people support, donations they've made, and people's stances on issues such as gun control, abortion, immigration, the environment, healthcare, and public education. Employment data, such as whether someone is a police officer on patrol, a detective, a judge, a staffer for a legislator, an active duty military service member, a healthcare worker, a public school teacher, or a student, and among many others, we have limited time today, whereabouts and location data, such as home addresses, work addresses, and even for some companies, people's real-time 24/7 phone GPS coordinates. Real-world data broker dataset titles include rural and barely making it, ethnic second city strugglers, retiring on empty singles, tough start young single parents, credit crunched city families, Jewish, working class, special needs kids, seeking medical care, and police chiefs by state. There are individual data brokers that will collect, infer, and package together of data points on each of hundreds of millions of people around the world. It's like the name 3 fun facts about yourself game on steroids. So what are the harms of selling all of this data? Well, data brokers collect without people's actual knowledge or consent. No matter what some companies might claim, years of peer-reviewed academic research, public polling, investigative reporting, and firsthand experiences underscore over and over again that people do not read privacy policies, people would not have the time to read privacy policies even if they plan to, and people would not understand privacy policies and how their data is being used even if they did want to read them, had the time, and actually did. In short, claims that all this gathered and sold with public officials' consent, or with police officers' consent, or with teenagers or domestic violence survivors or healthcare workers' consent, flies in the face of all available evidence. These are fundamentally invasive corporate practices. Once collected, the sale of data to a range of buyers also causes tremendous harm. Individuals have acquired phone location data from US data brokers to track, identify, and out a closeted gay priest, identify US military service members on overseas bases, leaving them to go to brothels, and be able to identify Americans visiting places of worship, domestic violence shelters, and substance abuse treatment facilities. Insurance firms have bought data on people's TV consumption or car driving, including how hard you pump on your brakes, to quietly inform their own modeling and business decisions. Scammers and criminals have bought data to target elderly people suffering from Alzheimer's and dementia, with scams that lost them collectively millions of dollars, as well as veterans looking to obtain benefits and everyday workers whose business emails and information are sold online. And most relevant to our discussion today, for decades, abusive and violent individuals have bought data from PeopleSearch data brokers without those individuals' knowledge for as little as $5 or $2 or even pennies, with no background checks, to locate, hunt down, and then harass, intimidate, assault, and even murder those people. This has long been and continues to be a serious, deadly problem in the stalking and gendered violence space, falling hardest on women, women of color, LGBTQ people, and children. And now, data is being used to target, assault, and even kill police officers, judges, elected officials, healthcare workers, and much more, including putting their families and children at risk. These harms are significant, which is why data rights in bills like H342 are so critical. Second, in response to these harms, data brokers often make a number of arguments. Data brokers say that collecting, digitizing, aggregating, and selling data from public records should not require any consent from people, and that it causes no difference or harm to the individual because the data is already out there. But this ignores the fact that taking something buried in a filing cabinet in a far-flung office building and digitizing it, analyzing it, linking it to you, and selling it fundamentally changes the risk to your privacy and physical safety. This rhetoric also contradicts their own marketing literature. The whole reason many data brokers say they charge someone for purchasing public records data is because they did all the work themselves of finding, digitizing, and packaging it. Data brokers say that collecting and selling your data also doesn't matter because it's easy for people, including law enforcement officers, judges, and public officials like yourselves, to get their data removed from the internet and to stop data brokers from selling it. Once again, these nice-sounding narratives fly in the face of substantial research and many people's hands-on experiences of attempting to get their data removed from the internet and stop many data brokers from selling it. Without comprehensive legal rights, doing so is extraordinarily difficult because of how brokers treat opt-out and deletion requests. In fact, one trade group recently implied that data brokers shouldn't even listen to consumers saying they don't consent to data sales unless the brokers are legally forced to. And, especially lately, larger data brokers will try to paint examples of harm as just a few bad apples and shift the conversation to talking about controls and best practices on data already collected. But this skips, intentionally, right over the fact of them collecting and selling it without your actual knowledge or consent in the first place. All to say, the data broker industry's privacy invasions, harm, and risks to public officials and their families makes measures like H342 a step to protecting people against this danger and starting to empower them to have more control. Thank you for your time.
Thanks, Justin. I'm just curious, in your studies of data brokers and things, I'm just curious, a question came up about like the number of, I'm not expecting you to know this number, but about the number of like data brokers registered in Vermont. And I know just from reading different articles and things that, and I'm just asking to kind of maybe confirm or expand and expand on, kind of the activity of data brokers that are operating as data brokers that are not registering and like the kinds of trends you see around that.
Yeah, it's an important question, as you noted, right, to ensure that, okay, obviously we've written XYZ provision. Are we actually seeing that kind of compliance in practice? So Generally, the number of data brokers in Vermont's state registry have been close to the number 500-600 or so in California and other comparable state registries. So in that sense, its registration numbers have been roughly equal to those in other areas. Certainly, there may be, because there are thousands of these companies and it's very obscure, firms that perhaps don't know they need to register or are claiming certain exemptions to registry that are not, I mean, I'm not an attorney, of course, but are not grounded in the actual compliance obligations that they have. For example, there are companies that are known to make statements about their coverage under credit reporting laws when they in fact are doing so inaccurately. So those are the kinds of exemptions I think that would be key to ensure compliance.
Sorry, just to confirm, did you say that there were about 500 or 600 registered in Vermont, like give or take, and that is comparable to what is registered in a place like California?
I have not looked, to be quite honest, in the last month or so at Vermont's numbers, but in the past, having looked and compared across all of them, right, and now Texas and Oregon have registries too, that is accurate. Yes, they have been roughly across the states equal in terms of the number of companies that are registered.
Okay. Do you think our population size has a bearing on like the kind of potential harm that could be done to our citizens, given that we're such a small state?
Certainly. As I mentioned, right, there are lots of similarities in the industry. Certainly no two companies are exactly the same thing, right, doing exactly the same thing. And so there probably is a bit of a higher likelihood that there are more firms that fall under California's remit for that reason. That said, most of these companies collect and sell from a variety of states. So I think the variation there is likely quite minimal.
I don't know if this is the right time to ask, are you familiar with the legislation that has been introduced here? And I think there was one suggestion made in another committee to change the 10-day period in which a data broker would be required to cease disclosing the information and increase that to 30 days. Do you have any opinion about that?
Yes, it's a great question. I think that as you're getting at, right, this is of course a challenge. There are companies that will, prefer to have that be 7,000 days, right? In their own interest, but there is obviously, it does take some time to match the records and remove them. All to say, if I were making a decision in that vein, I would veer towards sooner is better, right? Because we're not talking about, in this particular legislation, as you referenced, we're not talking about a general privacy concern or a general creepy ad concern. We're talking about a physical safety and security concern. So I would imagine that if someone is, newly submitting one of these requests, it's because they're worried about their safety, their family's safety. And so the need for that to get taken down as soon as possible is greater in this particular scenario.
Let's see.
Justin, for kind of the location of data brokers, like I am wondering about location of businesses like being actually in Vermont versus these data brokers being elsewhere in the United States and or the entire world. And if you could just speak to like the location aspect of data brokers and what we're looking at.
Yeah, a lot of them are not going to be or even have offices in Vermont. I mean, on the extreme end, right, there are data brokers that are run out of a PO box type thing, right, and they have a website and they just sell people's information that way. But plenty of the larger brokers, right, have offices around in different places around the country, Arkansas, Texas, New York, you name it. But I at least know that, of course, a number of them do not have a physical office presence in a state like Vermont.
So how many other states have taken up and enacted this type of legislation?
For this specific legislation, the state that has enacted it, as I think referenced earlier, is New Jersey. With respect to deletion and opt-out, I know that came up earlier. Generally, there are several other states I can name, but this one's just New Jersey right now.
Question?
Just, I don't know if you'll know this. I'm just curious. It's come up with just questions that have gotten in the building today around Consumer Financial Protection Bureau and that being gutted, and then the things that they were looking into regulating as far as like credit header data and things like that. I was just curious if you can speak to what that looks like. Just thinking about as we're like hearing from other witnesses.
Sure. So I'd say two things. One is this rulemaking you referenced that the Consumer Financial Protection Bureau still is technically undertaking. It was undertaking it with more vigor 6 months ago, but it is still exists, right? The first main bucket, I think, was the CFPB saying we've had the Fair Credit Reporting Act for decades, right? That's given all Americans federal rights to do things like view your credit report, correct your credit report. And there are nonetheless plenty of companies that are covered by the FCRA that do not behave like they're covered by the FCRA. So maybe they're not providing those correction rights to a consumer who wants to look at their credit report, or maybe they are putting in a website at the bottom of their website, do not use this for credit reporting, or something, right? But then are providing data for credit reporting. So the first main goal of that was just to clarify, we're talking about definitions here, right? That all the companies that are under that definition are being compliant. The CFPB assessed, I completely agree, there's a big gap there with FCRA. The second piece with FCRA was trying to crack down more on some of the harms. So contrary to what some have said, the CFPB was not eliminating the law enforcement exception for data access. They were not getting rid of credit reports completely, but they were trying to look at issues like stalking, for example, where, in a relationship, right, access to a credit score and other things can reveal people's personal information and can be used for abuse. So those at least were two of the many goals that they were looking to accomplish originally.
One more. I'm wondering if you can kind of, another thing I'm just trying to navigate in conversations today is basically when it comes to FCRA, kind of like credit reporting agency operations for being able to access, for fraud reporting and things like that, versus like the paid $15, you get access to people search type thing. I'm just wondering about kind of like the good protective aspects of, credit reporting, tracking and things like that versus like something that opens up people to be searchable,
Yeah, well, one is, as you're getting at, I think, right, this kind of legislation, of course, is not, again, getting rid of a credit report or saying no one can have a credit report, right? It is, as you're referencing, with respect to one of the most immediately physically dangerous kinds of data sales, which is posting your information online or selling your information online for $5 to somebody with a credit card. I won't, I know other witnesses will. We could sit here for an hour and go through the most horrific examples of murder and other things that have happened. So, but with respect to any associated benefits, I would approach that discussion approaching the FCRA discussion, right? Which is to pursue, to think of it at what is happening with the actual data, not the entity. So I'll give you an example, right? So with FCRA, there are companies that are covered by the FCRA that sell tons of other data that has nothing to do with credit reports, that have tried before to get a total exemption from privacy laws by saying we're FCRA covered. And the better approach has been to say, yes, we are going to exempt your FCRA related activities, but not your whole entity, right? Not all this other stuff you're doing that is not related to FCRA. So to me, we can get into, I think, the whole fraud. There's a whole bunch of issues with the fraud arguments that are made, but even so, right? If one were to write an exemption for something like fraud prevention, it shouldn't be that any company doing fraud prevention can do whatever it wants, right? It would be, as you're saying, that the specific data used for that specific purpose is permissible, right? So to make it, a narrow and purpose-driven discussion rather than, the entity writ large, if that makes sense.
Thank you.
Questions? Justin, thank you very much.
Thank you very much.
Sarah? Good afternoon.
Good afternoon. How are you? I'm Sarah O's, the Vice President of Government Relations for the Consumer Data Industry Association. And we represent credit bureaus and background screening companies. And I would, if I could, answer one of the questions Representative Priestley just asked the previous gentleman with regards to data broker and data broker registries. And I think one of the reasons why you see a consistent number of data brokers in all of the registries across the states where there are data broker registries is because Vermont was the first in the country to define what a data broker is. And those states have followed that definition. And so while there actually are other actors that are aggregating the same exact information, there's bought and sold that doesn't have consumer opt-in, that there are many, many more companies that are doing that. But because Vermont wrote the definition in a very specific way, they don't have to register. And so other states have followed suit. So you're seeing those companies are all registering in the various states. So I just want to be clear. It's not that there aren't other companies who are buying and selling and using this information in the same way. It's just because of the randomness, as I would argue, of the Vermont definition of data broker, and that has infiltrated into other states, that's why you're seeing it that way. So just first want to clarify that. And two, there are more than just New Jersey who have Daniel's laws like this bill that we have before us. So just wanted to clarify that for everyone. But with that being said, thanks for the opportunity to speak with you today on this very important bill. As you may know, Daniel's Law was introduced in New Jersey. It is in response to the tragic death of the 20-year-old Daniel Anderl, who was the son of Judge Esther Salas, who was shot and killed at his family's home. Several of these laws have been introduced across the country to protect judges and others in the public sector. The intent of Daniel's laws are to ensure that the PII of the protected class are not available to the general public, such that this information is not easily attainable from publicly posted databases, websites, or portals, whereby that information can be used to harass, intimidate, or worse, cause harm to those in the protected class. We believe it's very important to ensure that those in the protected class have the ability to protect this sensitive information, given the nature of their work. I personally have members in my family who have served as legislators and in law enforcement who benefited from their information remaining out of the public eye. This legislation, of course, is not a new concept, as many of these laws exist across the country that do provide protections for those in public service. However, this bill falls short of providing any real protections for the covered class. Instead, it provides the perfect environment for out-of-state plaintiffs' attorneys to clog your courts with unnecessary class action lawsuits. In order to protect the information of these public servants, first and foremost, the state has to protect these public servants' data. Third-party entities only know if someone is a judge or in law enforcement, and only because the state agency has identified them as such and provided that data. Most states with Daniel's laws state that the protected class must request to their state agency to cease reporting their information publicly on websites or searchable public portals, and they must comply within 72 hours of this request. This bill actually exempts the state from any liability or acting on this information. Second, the scope of Daniel's laws should be focused on publicly posting the information on the internet. And that is the key. Even Representative Priestley mentioned online, keyword there of having this information available. The goal here is to protect these individuals' information from the public who might gather their personal information from the web in order to harass, intimidate, or cause harm. In most jurisdictions, the protected class can also request the removal of publicly posted PII by any business or any businesses that are publicly posting this information, with the notion that the PII must be removed within a 72-hour time frame, regardless of their business model. It's unclear why this legislation has chosen to treat the protected class's information differently for companies who are disclosing the information simply based on a company's business model. If the point is to protect the protected class from individuals who want to cause harm or to intimidate, What is the rationale to limit that? Because that's just what this legislation does. It only focuses on what Vermont defines as data brokers and does not apply to any other businesses who have the same information and are even publicly posting this information on websites and public portals. The way the Vermont law defines data brokers, search engines, social media platforms, and most other businesses would not be required to stop publicly posting or disclosing this information, which are the very places where one does not want this information posted. This bill does nothing to prevent that. A simple Google search of the judge's name would still be allowed under this law, and their information could be found because Google is not a data broker under Vermont law. Instead, this bill focuses on a narrow group of businesses who have PII and prevents the disclosure of the information, even when disclosing the data may not be making this information public. The definition of disclose is extensive and goes well beyond making the information available to the public. The bill's language even appears to recognize the unusual and inconsistent nature of this fact, as it states that it shall not be a defense to liability in a judicial proceeding that the covered person's protected information is or was available to the public from other sources, on the internet or otherwise, or available by inspection of public records. So the bill itself recognizes that it is not prohibiting the protected class's information from becoming public. Additionally, denying a company's ability to disclose information, even when it is not publicly available, can have real unintended consequences for the protected class. Fraud prevention services can be impacted when companies are unable to transfer that data. None of the information is publicly posted or even available to the public. But if a company who is defined as a data broker under Vermont law has a fraud database, they would be unable to disclose that protected class's information. This could disrupt efforts to protect consumers from identity theft, fraudulent transactions, and similar financial crimes by prohibiting the sharing of information necessary to verify identities. The same is true for state services and benefits, state unemployment insurance, or state tax refunds that require authentication of applicants or beneficiaries of identities. There were issues with this recently in Delaware after they enacted a Daniels Law legislation with broad prohibitions on transferring of data. When a judge went to sell his home, he was not able to prove that he in fact owned the home he was trying to sell because the information was not allowed to be transferred to the correct business used to verify that information, none of which were public facing. This legislation, while it addresses a very important issue, protecting those men and women and their families who serve the state of Vermont, it fails on its face to provide any additional protections for them. Instead, this legislation creates the perfect environment for third parties, such as Atlas Data's Privacy, to act as an assignee to the protected class who sign over all of their rights to this company to sue on their behalf. Sometimes it's unclear if they are acting in the best interest of themselves or the people who have signed over all of their rights to them. And this is exactly what has happened in New Jersey. The original law that was passed after the tragic death of Daniel focused on removing information that was publicly posted. Subsequent changes were made to the law. The latest was made during the last minute, buried in an appropriations bill that added a private right of action, $1,000 statutory damages, attorney's fees, and the prohibition of transferring the data with a broad definition. Atlas Data Privacy would like us to believe after the bill passed that unanimously, roughly 19,600 residents who made up the protected class over a holiday weekend all decided at the exact same time to submit their request for companies to remove their information. The emails that companies received were all from an Atlas address with limited information on how to verify the person's identity and came from an Atlas domain where the individual could not easily be contacted. This resulted in 140 lawsuits. And if you do the math, and I like rough numbers, 140 lawsuits with roughly 20,000 participants and $1,000 for each violation, that equals $2.8 billion. The lessons Atlas has learned in New Jersey, they are simply trying to apply here. This legislation is a goldmine for plaintiffs' attorneys to generate legal fees, not to protect the public servants it purports to protect. The New Jersey law faced First Amendment challenges in federal court, and we are told by lawyers that this bill, targeting particular companies and excluding the defense that the information can be found elsewhere, looks as though you're trying to disfavor certain businesses. And as such, this legislation would be even less likely to survive First Amendment scrutiny. At least 10 other states have laws that have protected individuals from having their information put into the wrong hands. And I would encourage you to look at some of those where they don't have the same missteps that this law has. Missouri and Oklahoma are two that come to mind. The one in Oklahoma, the bill sponsor, actually spouse is a judge. We agree that Vermont should work to protect your public servants. However, this bill does not accomplish that goal. Instead, this is a lawsuit generating tool aimed at enriching plaintiffs' attorneys rather than protecting your public servants from harm. And with that, I would be very happy to answer any questions you may have.
Thanks so much, Sarah. I'm just curious, so at the beginning when we were talking about the data broker piece, you kind of highlighted a lot of potential gaps of what we're not catching. And so I'm just curious if you'd be supportive of expanding the definition of data broker to catch more companies, and what that might be if we were to kind of amend that as part of this.
I think that all data aggregators who have this information, who are publicly posting it on a website, should be held to the same standard. And I think it does not make sense that this bill actually says the fact that you can find this from other folks who are not considered data brokers under the law is not a defense for why you are being sued. And it ultimately shows that the bill isn't there, it isn't written and drafted in such a way that it's there to protect the covered class from having that information out there. Because if you're truly trying to protect the protected class, then it doesn't matter what business it is, it shouldn't be publicly available, easily searchable, something that can get into the wrong hands.
And I would just thank you. That helps. And I'm also just curious, as far as the, taking the action of, as far we were talking about, like you were talking about the background checks and things like that. I'm just curious, what kind of cases can people do background checks on people without their permission? Because this bill is trying to say like if it shouldn't get in the way of a consumer taking an action, like basically giving permission for an action to take place. So I'm just curious, is that happening? I guess.
I'm not sure I completely understand your question.
You referenced background checks, this getting in the way of background checks. And I thought people had to have I've had several background checks for jobs, but I always have to like give my permission. Is that happening without people giving explicit permission for that to happen?
No, and I think I was saying that fraud prevention databases and identity theft, that's where it gets in the way, not necessarily background checks. You are correct. In order to do a background check, the individual has to give consent, and I would agree that that wouldn't apply here. But where banks are trying to verify your identity when you go to log into your bank account, that information is a fraud prevention database. And the way disclose is defined as basically any type of transferring, sharing, you name it. That information could not be shared, which would make it harder to verify that it's Sarah O's going to Bank of America to log in those databases, that sharing. That's the type of thing that I'm talking about.
Thanks for your testimony, Sarah. Representative Herb Olson. Couple of questions. One kind of narrow. I'm trying to find it again, but I was looking back at the definition of data broker. I remember you talking about the someone in Delaware, which who was adversely affected by this type of statute, I think, because they couldn't transact. I think it was a real estate transaction or something like that.
Correct.
I can't find the darn thing, but my understanding, well, I don't know. I thought I read in our data broker statute that there was an exemption for, those kinds of transactions where I guess the person was using the data for, a transaction of that sort. Am I reading that wrong?
So I think it's conflating a couple of things. First, in Delaware, the bill doesn't apply to data brokers. It applies to any industry. It's not specific just to data brokers. So it says any company that has this information that's publicly posted. And second, even if you are a company that may have a fraud database or a database that verifies everybody that I represent has to register as a data broker in the state of Vermont. So all of my folks there are companies of ours who have databases that would be able to verify an individual's residence type of thing. And so under this law, because we are a registered data broker, we would not be allowed to disclose that information.
Okay, I'll go back to the definition. I didn't understand it to read that way, but I'll go back to that. Thank you. The other question I had, if I may, is just sort of broadly. I think obviously these kinds of disclosures can be, have very harmful effects. And I think what I hear you saying is, be careful about, what option you choose, I guess, to try to minimize or mitigate against that kind of harm. And I'm seeing sort of three sort of options. You either say to the entity that has the data, keep it private or whatever, make sure it can't be disclosed. You could also say to someone like Google, don't acquire it, right? Don't acquire and then post the data. And the third option is, I think, what's this bill is trying to deal with are individuals that buy and sell the data. So that's a sort of separate category. Is that the way you say it? I mean, and I could see different I guess, pluses and minuses about choosing each particular option.
Well, I think we would argue that there are plenty of companies that have the same information that companies registered in the state of Vermont as a data broker. They have the same information. They're using the same information, collecting it, buying and selling it, doing the exact same thing. It's just that you have an arbitrary definition of what is a data broker. So unlike the term telecom, there isn't a universal definition of what a data broker is. You guys just created it. I was part of that process, and you intentionally carved people out, not because that they were doing something differently or behaving in a different way, but simply because it was a different business model. And there were political reasons for that, not because any way, shape, or form that the information's being used in any different kind of way.
Yeah, and I wasn't around for that, but it just seems to me that it's a different sort of category of an entity, a business organization that actually is in the business of buying and selling. I mean, that seems to be a little different that seems to be a different category that I could see people saying, well, we're going to try to regulate the disclosure of private information in this manner. Yeah, I'm sure you don't agree. I'm just thinking that
I don't disagree, but I think, again, it goes back to the definition of data. Credit bureaus are considered data brokers, but that's not their line, their full business. But because I don't sell a credit report to and have a direct relationship with the consumer, then I'm still considered a data broker, even though I'm not just randomly buying and selling information that the individual doesn't know that I have, right? So I think that's what I'm trying to just open up and consider. I don't disagree with what you're saying. I'm just saying there's more entities out there that are doing what those on the registered list are doing. And so I think everyone should be treated equally there.
Okay, thank you.
Do you have an example, or can you point to an example of what you think is a comprehensive definition of data brokers?
If we had, yes, I think the best definition is any data collector. I think you just take out the direct relationship, right? When definition. Sorry?
No, nothing. I understand. Thank you.
Yeah, just a question kind of around enforcement, but it's just like hypothetically, like if you had, I guess, expecting people to follow through if they receive a direct request to have like home addresses removed, like what would you say to a member if they like just failed to, after receiving multiple notices after like a year, to do this? And I guess like part of this law is trying to make that happen along with like having the enforcement mechanism.
I think enforcement mechanisms in anything, they make people comply. But I would say, again, this bill right now doesn't just apply to publicly posting. It applies to any B2B transferring of information, which to me doesn't make any sense, because the intent of Daniel's law is to ensure that this information is not in the general public's hands, so that you can't do a quick search of a judge or law enforcement or anybody in the protected class and readily get that information and cause harm. And so I think that should be the focus, is removing that out of the public domain, rather than focused on other transactions that have the potential to disrupt commerce.
Great, Sarah, thank you very much.
Thank you. Appreciate it.
We do too. Okay. So I know Garrett, Debbie, Jeff, and Colby. Are you able to join us tomorrow?
Hi, this is Garrett Rogers. Yeah, I'd be happy to join tomorrow.
I'm good for tomorrow. This is Jeff.
Okay. Debbie?
I can try to join tomorrow. My schedule is tight tomorrow, though.
Why don't we hear from you now?
Okay.
We just want to make sure we can hear from you. Been a long day, but we're willing to go a little longer. And I appreciate Garrett and Jeff. Thank you for being able to come tomorrow. And
Well,
Colby,
thank you.
yeah,
Colby's with Jeff, so.
Colby's with Jeff.
Yeah.
Okay, perfect. Thank you. Go ahead, Debbie.
Okay. Well, first of all, can you see me? Hold on. Hello.
Yeah.
First of all, thank you. Thank you for having me, and I appreciate being able to listen in on the testimony and also your deliberations today. So thank you to the chairperson, the members of the committee, to have me speak today. I will try to keep it at 10 minutes. I know it's been a very long day. I have previously submitted a written statement, so I will go over that statement. And if you all have any questions, please let me know.
Thank you.
So my name is Debbie Reynolds. They call me the Data Diva. I'm the founder, CEO, and Chief Data Privacy Officer of Debbie Reynolds Consulting. I work at the intersection of data privacy and emerging tech. My work is in 4 particular areas. So I work in advisory, consulting, standards, and I do a lot of speaking. So I will actually share my screen for a bit. Give me a second here. Can you see my screen?
Yeah.
Yes.
Okay. So just to give you an idea, so I recently did a speaking engagement for the U.S. Senate on privacy and safety, and that's what I'm going to be talking about today. I also chair the IEEE Committee on Next Generation Connectivity Systems as it relates to data privacy and human flow. I was one of 16 Americans on the IoT Advisory Board, and we actually had a report that came out in October of 2024, and I ran the privacy part of that committee for all the government sectors, or also all the economy sectors that were represented in that report. It's like 16 sectors. I'm also the host of the Data Diva Talks Privacy Podcast. It's the #1 data privacy podcast in the world for 5 years, with listeners in over 120 countries. And also I'm a keynote speaker for a lot of companies you never heard of, like TikTok, PayPal, Uber, and the like. So I've been in technology for over two decades. My work in privacy, it actually started as a personal interest, but I very much was happy to turn that into a business. And so I look very closely at privacy in all sectors, in all areas of the world. And I've taken a very keen interest in Vermont and what the work that you guys are doing there. One thing I want to talk about is why this bill is important and why it's necessary. There are inherent risks for public servants, especially right now in a digital age where a lot more of your data is available, and it also is being packaged and sold by companies that likely don't have a relationship with you as a consumer and really can't help you. I think a previous speaker had said something about an example about someone not being able to do some type of property transaction because of because of particular law. But people have been buying and selling houses for many years, and they didn't need data brokers to do that. So I don't know where that came from. A lot of this data is unfortunately being used against public servants for stalking and intimidation. Actually, a lot of victims are stalked and tracked based on technology, based on the statistic that I gave. Also, 1 in 4 Americans have been doxxed, meaning that their private information has been put out on the internet, a lot of times for intimidation. I think one of the examples that Monique gave was that a particular public servant was sent a pizza to their home address in a way to intimidate them. And also swatting, having maybe law enforcement come to your home or your residence based on a false report of some other type of emergency, which will create another type of harm. Also, real world harms. The speaker before talked more in depth about Daniels Law, which was put into place in 2021. I also talk a bit about the Amy Boyer case, where she was murdered by a stalker who purchased her data from a data broker. And then also the FTC had taken some actions in 2024, most notably, not the only action, but about Gravy Analytics and Mobilewalla, who were taking people's sensitive personal location information. I also want to say, when you think about data brokers and the data that they collect, it could be very wide ranging. A lot of times it could be real time or near real time information that's tracked. So let's say your whereabouts, literally almost to the minute. Those types of things can be bought and sold and tracked about a person. And I think a lot of people don't really imagine or understand the breadth and the scope and the scale and the speed in which some of this data is being tracked. So Vermont was a pioneer actually in this area. So you were the first state to have a data broker registry in 2018. So I think you recognize early the risk and why consumers as a whole need to have more visibility into this particular industry. I believe that this bill builds on that success. I don't want to see public servants harmed. You're doing a very important service to the people of Vermont, and to rebut some of the claims from the data broker industry, when they talk about their, they talk mostly about their concern about litigation, right? And the fact they feel that they provide a valuable service. But as I like to say, and I've said in the past, you can't take advantage of a service if you're dead. So it's very important that we get this right. It's very important that we talk about this not as a privacy issue, but also as a safety issue. So I also believe that this law provides more of a consistent framework for civil servants and public servants to be able to help them, give them some agency and control, whether it is them making the request or having an agent make the request on their behalf. The fact of the matter is that your digital footprint is sprawling. So being able to have even a registered agent help you in this type of thing is very important. And I know a lot of times the data broker industry doesn't want to see that. So there's actually a very important case that happened in New Jersey, and this is about Daniels Law. So a lot of data brokers were upset because they didn't want to do all these opt-out requests for public servants. And this particular case said that the personal data sales is not constitutionally protected speech. That's what the New Jersey court said. And so it's pretty significant. Also, I think it's in the public interest to be able to protect public servants and the work that they do. You know, you do so much for the public, and those sacrifices shouldn't mean that you're also sacrificing your own safety. And there are precedents, as some of the other speakers have said. In addition to Daniels Law in New Jersey, there are similar laws that have also been passed or are being contemplated around this particular topic, which is protecting the data of public servants in Hawaii, Iowa, Missouri, Maryland, and New York. So I think that this is an idea that's caught on. So I think it's definitely a good idea. I think the bill is narrow. I would love to see kind of more, but I think it's narrow enough, saying that, you know, we want to make sure that these group of public servants or civil servants have this particular protection in terms of how their data is transmitted from these companies. You also have existing regulations. So I know someone has said previously about like credit bureaus and things like that. So credit bureaus, they are covered under the Fair Credit Reporting Act. So that's where they're regulated. And also Vermont has particular regulation around people who are doing private investigations, right? So a data broker, as we're defining it, doesn't fall into any of those categories. So they aren't regulated by either of those things. And that type of regulation is possible, right? So the people who are in these security services and private investigations and also credit bureaus, they're not begging for bread because they can't do business as a result of these types of regulations, which are far more strict than the things that we're contemplating today. So the idea is really to protect public servants in Vermont, built on proven legal precedents, align with some of the privacy best standards, and also provide leadership. So I think that this is a measured, necessary bill. It's very narrow. It's not super big, and I think, in terms of the time, it's fine, whether it's 10 days or 30 days. A lot of this data, if you were to ask a data broker, if you want to buy someone's data, you could probably get it in hours as opposed to days. So I think, this is a very urgent need. And, I'm particularly driven by the fact that I don't want to see anybody else harmed or killed as a result of their data being sold. That's it. Any questions? At the end, I have two videos here, links in my submission, just short videos about Daniels Law and everything I talked about in terms of the constitutionality.
Thanks, Debbie. And your videos were great. Daniels Law one was very helpful in understanding and being able to share that quickly. I am curious if you could speak to the kind of the previous witness as far as like this law interrupting commerce. I'm just wondering if you see that or yeah.
I mean, it's not clear to me how their commerce benefits the individual, right? So if the commerce, people give data to companies every day if they feel like the data is benefiting them. And I think what this law is saying is there is a harm with their data being out in public spaces, being traded to whomever without their knowledge. So being able to give public servants in Vermont the ability to be able to say, I want to opt out and make sure that my data isn't traded or sold, I think it's kind of a very reasonable step. I hope I answered your question.
Yeah, you did. Thank you.
Herb?
I'm mindful of the time.
No, it's fine. If you have a question.
Well, I following up on Malik's question. So I think the previous witness had said, well, somebody, and again, I think it was a different law, it was a Delaware law. And so,
Yeah.
interfered with their ability to sell their home because in order to sell the home, they had to have information. It sounded like a credit report of some sort, or some sort of information about the financial status of the purchaser or mortgagee or whatever. Do you see? What do you think about that argument?
You don't need a data broker to sell anything. So I don't know where it got that from, right? So if you're selling a home, you need to establish your identity or credit worthiness. That typically is handled by a credit bureau, which is regulated by the Fair Credit Reporting Act, which the data brokers are not.
Yeah, and that was kind of my understanding too. When you buy and sell a home or something, you usually expressly consent to the transfer of that information.
That's right.
Other questions? Great. Debbie, thank you for joining us this evening. We appreciate your time and thank you for your expertise.
Thank you. Anytime. Thank you.
Thank you. Committee, I think we'll wrap it for tonight. We'll come back tomorrow, 9 o'clock. We'll be looking at a draft on CTE. And then I think around 11, we'll get back into discussion on this bill, 342. So
Is the CTE draft available?
it's the draft that's going on right now. So we'll probably all get to look at it. Correct. If it comes in tonight, we can pass on around. Otherwise, we're reading more. Okay. Any questions before we go?